Welcome, and thank you for your interest in Venable's nonprofit webinar, Office Leasing for Nonprofits, Mastering the Key Issues. The program will begin shortly. We apologize in advance for a technical difficulty which caused an interruption in the advancement of the slides toward the end of the webinar. Complete presentation materials for this program are available on our website at www.venable.com/nonprofits/recordings. Please enjoy the webinar.
Good afternoon, everyone, and welcome to those of you here in our offices in Washington, D.C., and good afternoon and good morning to those of you joining us from around the country on the webinar portion of our program today. We have a nice crowd here in D.C., and a really nice crowd of, I think, about 150 to 200 people on the telephone here today around the country. So thank you for joining us for our program entitled today, Office Leasing for Nonprofits, Mastering the Key Issues. My name is Jeff Tenenbaum. I'm the chair of the nonprofit organizations practice here at the Venable Law Firm. As many of you know, because many of you are regulars, this is part of our monthly series on nonprofit legal issues that we've been doing now for getting close to 2 years on a wide array of legal issues. This is the first time that we've covered really any topic relating to real estate and office leasing. As you know, for those of you who have joined us for many of our prior programs, we do try to kind of cover the waterfront, make sure we cover a wide array of different types of legal issues that face and challenge nonprofits. Some tend to be hot button, breaking news, new development type issues, and some tend to be some of the oldest issues in the book, but that are equally as important. And today's topic probably falls into that latter category. It's an area that we counsel many of our nonprofit organizations on. It's not an area that I personally am terribly fluent in, but I am very grateful to have some very talented colleagues in our real estate group in all of Venable's offices that work regularly with our nonprofit clients. 2 of them are here with us today. We're very fortunate to have with us, to my immediate right, is Suzanne St. Pierre. Suzanne's in our New York office, just joined our firm about 6 months ago. Joined us from another firm as part of a group of lawyers that came over to Venable's New York office, real estate lawyers, but with a real specialty in nonprofit organizations. It's been a pleasure to get to know Suzanne and her colleagues and to get to work with them a lot. Suzanne's a very accomplished real estate lawyer and also really understands nonprofit organizations and a lot of the unique aspects that come along with being a nonprofit in the real estate setting. I think you're going to be very pleased and fortunate to hear from her today. To Suzanne's far right is Jennifer Bruton. Jennifer is also a partner in our real estate group here in our D.C. office. Jennifer and I joined the firm around the same time, around 13, 14 years ago, and we've been working together ever since. Jennifer has been always my go-to person when it comes to real estate matters, purchases, leasing, and everything in between here in our D.C. office. She's terrific, and I think you're going to really enjoy hearing from her today. She's also the administrative partner here in our Washington, D.C. office. A few logistical matters. First off, in terms of questions, we do encourage you, as you know, to ask questions throughout. For those of you here in the room, raise your hands. I'll call on you. Our speakers will repeat the questions for those of you on the telephone, but no need to hold your questions to the end. Feel free to ask questions throughout. For those of you who are on the phone, you need to pose your questions using the chat feature on the webinar software. I'll be manning that laptop in the front of the room, and we'll pose questions to our speakers at the appropriate times. In terms of handout materials, you should have a copy, or you do have a copy of the PowerPoint presentation at your seats here in Washington, and those of you on the telephone should have had a copy of that emailed out to you. Keep an eye out tomorrow for, as we always send out a follow-up email that will, of course, have a link to the handout materials and the bios for the speakers, but we'll also have a recording of today's program, as we do for all of our programs. Feel free to share that with colleagues or others who might benefit from it. And as many of you know, we keep the recordings of all of our monthly nonprofit legal series on our website. You can find those at venable.com/nonprofit/recordings. And that link, along with some others, are on the final slide of today's PowerPoint presentation. So with that, and without any further ado, I'm going to turn it over to Suzanne to get us started. Suzanne?
Thank you, Jeff. Good morning, everyone. Good afternoon. Jeff is very diplomatic. Jeff is a very cutting-edge guy, and when he came to me and asked me if I'd like to make a presentation to the nonprofit clients and friends who join us on these webinars, and I suggested leasing as a topic, his face fell. He is on the cutting edge of nonprofit law, and he was really looking for a nonprofit topic that in the realm of real estate that I could share with you. But what I told Jeff, and I think the way I convinced him that we should talk about leasing today, is that for every organization, large, small, for-profit, nonprofit, leases are one of the organization's most significant obligations, one of its most long-term obligations. And it's essential that you get it right. And I think for nonprofits, there's a whole additional dimension to leasing. Leases are not written with nonprofits in mind. And we all know that nonprofits operate in somewhat different ways than for-profit organizations. They're organized in different ways. They have different business objectives. And what a nonprofit really needs is a lease that is tailored to meet those objectives. So we're going to talk today about leasing, and I think our discussion is going to range from some rather basic topics to some more complex concepts. So I hope that there is something in the presentation for everyone. We are going to look at a lot of these topics from the perspective of the nonprofit tenant, but we will also spend time talking about how these issues affect the landlord and what the landlord's perspective may be on these issues. We're also going to show you a couple of pictures of some great nonprofit spaces, because when you practice real estate law, one of the fun things you get to do is actually see what you are working on and share pictures of your projects with others.
And Suzanne, yeah, we'll grab that for a second. Apologies to I neglected to point out, I'm not going to run through them here today, but on your screen right now is the listing of our upcoming programs that we have scheduled. We actually have 4 programs already scheduled for the next 4 months, while February's is still being nailed down. So we have some really interesting topics. Actually doing a second program later this week for those of you who are interested in nonprofit postal issues, and then programs scheduled for December, January, and March, February to come. But take a look at those, and if those are of interest to you, there's some really great topics, some fantastic speakers. I would certainly encourage you to attend. Sorry about that.
Okay, so our agenda today, first I'm just going to make a couple of remarks about different types of leases. Then we're going to spend a little bit of time talking about the leasing process, best practices. Then we're going to turn to the topics, the principal financial terms of leases, and not only monetary terms, but terms that really going to impact the bottom line of the nonprofit. And I'm going to start that discussion, then I'm going to hand it over to Jennifer, and then I'm going to come back at the end and talk a little bit about some green building issues that come up in leasing, because I had to give Jeff some little bit of cutting edge topics, so we work that in. So there are basically 2 types of leases, net leases and gross leases. In a net lease, the tenant pays directly all expenses of operating the property, all taxes, maintenance, all capital improvement costs. The tenant operates the property as its own, doesn't get any services from the landlord. You'll see references to the term triple net lease. That's a type of net lease. You'll see in the lease itself, the rent is absolutely net to the landlord. That means that the landlord takes your rent check and puts it in the bank and doesn't take out any money from there to run the building. On the other side of the spectrum are gross leases. So this would be a typical example of a situation where a net lease would be appropriate is if your organization leases an entire building. On the other end of the spectrum, gross leases. In a gross lease, the tenant will pay additional rent on account of increases in operating expenses and taxes that occur during the term. They'll be responsible for some maintenance costs, mostly within their demised premises, and they'll contribute to the cost of certain capital improvements for the property. In the case of most gross leases, the landlord operates and controls the property and provides services to the tenant. And this would be a typical form of lease for an office in a multi-tenant building like the one that we're in here today, or say some type of ground floor premises in a mixed-use building. Now, in certain parts of our presentation today, we're really going to be talking about gross leases. When we're talking about operating expenses, taxes, and utilities and services, our discussion is really in the context of gross leases, because in net leases, it's really a lot simpler. The tenant is responsible for paying typically the full amount of those expenses. So here's a great nonprofit space. Dance Space Project is a nonprofit that presents modern dance in leased space. You're looking at leased space in a 200-plus-year-old Episcopal church in the Lower East Side of Manhattan. Okay, so the leasing process. First thing that we recommend that you do in the leasing process is to work with your architect to assess space needs. And you'll hire the architect, and the architect will talk with you about what your current needs are, what your plans are for the future. Are you downsizing? Are you expanding? What do you hope to do in the future? And the architect will develop a program, which is simply a written description of what your premises will consist of. So that might be 4 conference rooms, a breakout room, 20 offices, 30 cubicles, whatever your needs are. And what the architect will also do once he or she has all of that information is give you a sense of the size of the premises you need. Once you have that information, you can start working with a broker. Of course, you should sign a written brokerage agreement with a broker, and we do recommend that you include an attorney in that process. Brokerage agreements are typically for a fixed term. We recommend 6 months because if you haven't found anything that suits you within that period, you might want to start working with someone new because you probably have a space that you need to move out of, and time is always short in these cases. The landlord is typically responsible for paying a commission to a broker. Sometimes nonprofits say to me, I'm in a bit of a quandary because we have a foundation who funds us, and they may have space that we can use, but we don't know, and we only have 6 months left on our lease, so we want to get started looking for space and pursue this on a parallel track. Fine, you can do that. What you should do is you should carve out a lease at that premises from your brokerage agreement because you've already put in the work, you have that relationship, and you should explain to the broker what your reasoning is, but that's a space that you found yourself, and you should negotiate up front and tell the broker up front so the broker understands that you are pursuing this on a parallel track so that there's disclosure and no misunderstandings. Typically, brokers work on an exclusive basis with you, and the reason that they're willing to take you to see so many spaces and work with you is because typically the deal is regardless of where you end up taking a space, they are going to be paid a commission. So then you'll go to locate a property, and there are geographic considerations, of course. You're going to look at the type of building services that are provided in the building, see how that matches up with your needs. You should also really look carefully at the age of a building. I think for many years as users of buildings, we know that risers, the vertical spaces where data and telephone, computer, all types of lines run up the building, those are constrained spaces, and older buildings are not designed with today's data needs in mind. So you want to be sure that that building has enough capacity for your needs. Another consideration that people don't focus in on as much, and Jennifer's going to talk about this a little bit later, is unless an old building has been retrofitted and building systems have been renovated, it can be a lot more expensive to run an old building. And who's going to pay the cost of that? You are, as tenants. So an old building may seem like a bit of a bargain, but you need to have the whole picture and understand how the rent relating to operating expenses compares in a new building and an old building. Now you're going to go back to your architect once you've located a space, and the architect is going to work with you to make sure that that space is suitable for your needs. They're going to look at your electric and your HVAC, which means heating, ventilating, and air conditioning needs. They're going to see how those needs can be accommodated in the building and the space. They're going to tell you what improvements you may need to make to the premises. They're going to tell you if there are any permits that you're going to need in order to operate in that space. Maybe the certificate of occupancy has to be amended. maybe your contemplated use is not even permitted in that building. So those are discussions that you need to have with your attorney and your architect up front, because a landlord never takes the risk that you will be unable to get the permits you need for the space that you're renting. So if you were thinking of doing something that requires a special permit, like an assembly permit is required for a room like this, or if you're going to have a kitchen in your space that requires a permit from the health department, you need to speak with your architect and be really sure that this is an ordinary course type of transaction that is going to be easily approved and that you can get the permits that you need. Okay, so once you've made that determination, you can put pen to paper and negotiate and sign a term sheet. This is typically provided by the landlord or the landlord's broker. The terms can be modified by the parties. It's non-binding. It should include all of the essential terms of the lease for you. And then you'll see my last line here is underlined. Legal counsel should review the term sheet. And this is one of the best pieces of advice that I can share with you. Over the years, I've been involved in so many situations where a term sheet is missing some really important term, or there's something that's slightly ambiguous. And you might say to me, well, what's the big deal? You just told me that this is non-binding. I can just send my lease to the attorney once we have a first draft from the landlord. What happens in leasing transactions is that term sheets take on lives of their own. It is very rare that what is in a term sheet is renegotiated in the lease. So it is non-binding in the sense that you can walk away and look for another space, but I will tell you from experience that once that term sheet is finalized, that really carries the day in terms of what has been agreed to, and it's really hard to back off of that. So you can save a lot of time and money and legal fees down the road by making sure that's right at the outset. Then, of course, you have the lease negotiation, and really here, best practice is to get your team involved early, and we've put out a little timeline here for you. And I think based upon what I've said, you can see that it's important to know, say, get the architect involved early to know that that space works with you, for you, before you engage an attorney to start working on a lease draft. So this is the process that we recommend. And here we just have a list of some of the principal financial and legal terms of leases, and you'll see that there's one column on the left that has items that are typically addressed in the term sheet, and then on the right are other important lease terms. These terms aren't written in stone. If you see something on the right side that you would like to have included in your term sheet, I encourage you to add that in. Landlords have set forms of term sheet. They want to get your signature on that bottom line, even though it's non-binding, and get started. So they probably aren't going to offer a lot of things up. They may say, we can get to that when we get to the lease, but if you want to hammer these things out up front, you can certainly get into any topics that you want in the term sheet. There's another nonprofit client, the Municipal Arts Society, with a great nonprofit office space that they moved into a few years ago, also in New York City. Okay, so now we're moving on to some of the principal financial terms, and we're starting with termination options. And I'm starting with this, but I'm starting with it because it's something that clients ask for a lot. They ask for it at the beginning of a lease when it's being negotiated, and they also come back during the term and say, is there a way I can get out of the lease? So I put it first because it's a frequently asked question, but it is a very hard right to obtain. Landlords do not want to give termination options. They want you in there for the standard term. In New York, that standard office lease term is 10 years. 20 years is not uncommon. If the landlord's going to give you that right, you really have to have a real unique case as to why you need this right, and you're probably also going to have to pay a pretty hefty termination fee. And that's going to include the net present value of a certain amount of rent, several years of rent. It's going to include the landlord's unamortized costs. What are they? Well, if they built the space out for you, there's a build-out cost. If they paid the broker, there's a broker's fee. And sometimes this right will be restricted. Maybe you can have that right at the last couple of years of the lease term. But this is a very difficult right to obtain under ordinary circumstances. More common right, of course, is the renewal option. This is a great option for a tenant. You get in a space, you like it, you like being there, you want to stay there. You don't want to go through the disruption. You don't want to have to hire a whole bunch of professionals at the end of your 10-year term. So what you should try to do is negotiate for extensions. I'd say what's typical in New York is if you have a 10-year lease, maybe you'll have an option to extend for 1 or 2 periods of 5 years each. It's not automatic. There's always a requirement in the lease that the tenant notify the landlord that they're going to exercise that option, and time is always of the essence. So really, you're 1 day late and you've blown the right. So it's really very important to put that in the calendar and put the date that's 6 months before that in the calendar and sit down with the decision makers in your organization and decide whether you need to move on or whether you want to renew. So you can get that notice out in a timely way. And it's typically, a nice window, like a 4 or 6 month window to exercise the option. So it's not that it has to be done on 1 day, but you can't miss that day. Renewal rent is typically either 100% of fair market rent. Sometimes it can be slightly less than that, 95% of fair market rent, in recognition of the fact that the landlord is also saving a lot by not having to show the space again, by not having the space empty, by not having to pay brokers, by not having to do new build out. And fair market rent can typically be determined by using baseball arbitration. That's what we call it in, I guess, baseball obsessed New York City. Jennifer tells me in Washington it is the 3-broker method. But typically the landlord will send a notice to the tenant after the tenant has sent the notice saying, I'll renew, and they'll state the renewal rent. The tenant has a certain period of time to write back and say, we accept that rent, or if you reject it, you're going to have your broker professional provide you with a fair market rent value, and you're going to share that with the landlord. And then if the two cannot come to a meeting of the minds, you will have a broker come in, that third broker, and that broker is going to pick either the landlord's number or the tenant's number. So this is a method that is thought to keep the parties honest, because if you pick some rent that's really outrageous, whether it be high or low, and the arbitrator is required to pick one or the other and not something in the middle, they're going to pick what is more reasonable, what is closer. And the cost of this arbitration is split 50-50. Now, one thing to keep in mind is the way that these options usually work. You do not have the option as a tenant to back out, to cancel the option if you don't like the rent determination. Once you exercise the option, it's not revocable. So you are taking a bit of a chance because you don't know exactly what the rent will be, but that's common. Expansion options are not as easy to obtain as renewal options. They're typically styled as a right of first offer. So if space becomes available in the building, specified space that you've mentioned in your lease, the landlord has an obligation to offer it to the tenant before they can go out to market with it. And the tenant has a time period, time of the essence again, where they have to notify the landlord that they wish to lease the space. Rent is usually determined on a fair market value basis, the same as in the renewal term. If the expansion option is exercised somewhere near the beginning of the term, it may be possible to negotiate to key the rent for the expansion space to be the same as the rent for the rest of the premises. That's negotiated. You really need to make a business case for why you need an expansion option. And the reason for that is, let's think about it from the landlord's perspective. Expansion options are really difficult for a landlord to administer. What if every tenant in the building wanted rights here, there, and everywhere? The landlord would have to go through a list of people, keep track of them. Okay, first Venable wants this space, then XYZ wants it, then ABC wants it, and I have to give them all notice in 20 days to tell me in order if they will take this space, and then I can go to the market. Well, if you have a situation like that, if you happen to be lucky enough to have a tenant up front who wants to take that space, that tenant is going to have to hang around for 60 days plus notice periods so that everybody can think about the space and pass on it before you can pursue the negotiations with the tenant. And nobody wants to be in that position. So it has to be a space that makes sense. It has to be a tight time period from the landlord's perspective. And there really has to be a business reason. You're growing your company. What have you done in the past? Can you show precedence that you've had this type of growth before? Why this particular space? Why does it make sense for you? The next topic that we're going to talk about are real estate tax payments. Now, in gross leases, real estate taxes and special assessments are reimbursable under leases. And in order to determine the payment, you determine first the base year. And this is typically the tax year of the municipality, which occurs during the first year of the lease term. And we've shown you here the tax years for various municipalities, and this obviously varies widely. And the way that the calculation works is that the tenant pays its percentage share of the increase in real estate taxes over the base year. And that percentage share is calculated based on the rentable square footage of the tenant's premises divided by the rentable square footage of the entire building. If you start renting the space toward the end of the tax year, if I'm in New York City and it is May 30th and I'm entering into my lease, I may ask the landlord to make my base year a blended year. So let's make it the 2012, 2013 / 13-14. Let's make it some combination of that. Let's do a mathematical formula so that I'm not prejudiced by the fact that my lease started right at the end of the tax year. And that is something that can be negotiated with landlords. So typically what happens is the landlord will estimate the tenant's portion of the real estate taxes, and estimated payments will be made and paid monthly. And then at the end of the year, when the actual tax bill is received by the landlord, any shortfall or overpayment is adjusted between the landlord and the tenant. Very large tenants are able to limit what those estimated increases are. If you're a very large tenant in a building, you can say to the landlord, I should not have to pay more than 103% of last year's actual taxes as my estimate. Why? Because why not keep your money? And then you can pay the landlord if you owe more at the end of the year when you do the true up. Another thing to keep in mind are special assessments and abatements. And we recommend that tenants perform due diligence, obtain representations if possible from the landlord about special assessments and abatements that are applicable during the term. So what are special assessments and abatements? A special assessment is really a special tax that could be a one-time tax, or it could be an annual tax that relates to local improvements. So maybe your building is located within a business improvement district. The business improvement district has the right to levy a special assessment to pay for the street furniture and the flags and the lighting and all the nice things that they do. Or it could be a one-time thing or a couple of years. Let's say there are some utility improvements. They're upgrading the sewers in the street or the water or something like that, and they're going to levy an assessment. That would be a special assessment. An abatement is a temporary exemption from taxes, and it's typically for a period of years. It can be 100% exemption. It can be some lesser percentage. When an abatement is in effect, it can phase back in over a period of years, back to 100%. So why is this important to you? In the case of a special assessment, You want to understand what that assessment is and whether it benefits you and when it might occur. If there is a special assessment that really has no benefit on you, you may be able to talk to the landlord about excluding that assessment from your tax payment. And then we should also think about the case where there might be some special assessment that is payable in year 9 of your 10-year lease for an improvement that is not going to be available to be enjoyed by the building occupants until the year after your lease ends. You don't want to pay that type of an assessment. You get no benefit from it. At a minimum, let's prorate your obligation based on the useful life of whatever that improvement is and pay some pro rata share. So that all has to be negotiated up front. Abatements are tricky because they can end during the lease term, and if you're paying increases above a base, if your base is artificially low because your building is subject to an abatement, when that abatement ends, suddenly your taxes are going to go up. So if you know that there is an abatement in effect in your building in the base year, you can negotiate that. You can say when the abatement goes away, we readjust the base year so that the tenant is not prejudiced. Real estate tax exemptions, of course, are an issue very near and dear to the hearts of nonprofits. This is a key issue that nonprofits consider in the decision to own or lease real property. And we're going to take you through a couple of examples here, but the bottom line is that as a tenant, this exemption is only available to tenants in very narrow circumstances. Of the several jurisdictions that we're going to talk about, New York City is the only one that provides an exemption to a nonprofit tenant, and it's very limited. Both the landlord and the tenant have to be nonprofits, certain types of nonprofits described in the law, which includes most 501c3 entities. The tenant has to use the space for exempt purposes, and the amount of rent collected by the landlord may not exceed the landlord's carrying, maintenance, and depreciation costs associated with the leased premises. You put these numbers to the test when you have an actual premises in mind. I think in many cases you'll see that the total of those costs do not approximate a fair market rent. So it may be that if you are the lessee of space from some related organization or someone who, in furtherance of your and their mission, is providing you with space at a below market rate, you may be able to work together and preserve the benefit of the exemption in New York City. But if you're just paying a fair market rent and the owner happens to be a nonprofit also, you can't assume that that exemption is going to be available to you. I'll mention briefly, we could probably do a whole hour on this, that in New York City, a nonprofit owner of units in a leasehold condominium is eligible for exemption from real estate taxes under certain circumstances. This only applies to very long-term leases, 35 years or more, and there are other requirements. But this is something, if you're in New York City and you do have a pretty major lease, and it's great if you think about this when the transaction starts, so you can, instead of negotiating a lease beginning to end and then figuring out how you're going to convert that business arrangement into a condominium, it's best to start with the understanding that you're going to form that condominium, get the landlord's cooperation on that. But that is not widely used, but that is possible, and it is respected by the New York tax authorities. You'll see now in Washington, there is no exemption. The nonprofit has to be the owner and user of the property. There's no tenant exemption. Maryland, same thing.
And one comment just on D.C. It's actually much more narrow, the exemption, than the slide suggests. It's not, like in some states, any 501c3 entity that meets certain defined purposes is eligible to qualify. In D.C., it's incredibly narrow and actually very difficult to qualify for a real estate property tax exemption.
Yeah, and it's similar in Virginia and Maryland. It's not any type of use. It's a charitable or educational type of use. So.
Right. So we have a couple of slides on that. So that's something that is going to be hard for nonprofits to avail themselves of. Just to wrap up on real estate taxes, Leases do not typically come to you from the landlord with some limit on the period for collection of tax payments, which means that the landlord could send you a bill if they realize that they've underbilled you by the for taxes, or if the municipality sends them additional tax bill well after the lease has ended. This is kind of a nightmare. You've moved on. You don't want to pay this bill. So we recommend that you negotiate it for a limited survival period of 1 or 2 years. We also strongly recommend that tenant have the right to audit. This right is in a lot of leases. A lot of first drafts of leases from landlords you see have this right in there. Tenants rarely avail themselves of this right, and they really should, because it's fairly common that there can be errors that result in overbilling to the tenant. There are companies that do this work. Sometimes they do it on a percentage fee basis. You can also have someone from your organization go and review these books and records, and this is true of real estate taxes as well as operating expenses. One thing to keep in mind is that if you don't do this, an error that may occur in year 1 or 2 is compounded and continues until it's caught. And it's a lot easier to get the landlord to agree that they made a mistake and they need to give you a refund if that happens in year 2 than if it happens in years 2, 3, 4, 5, 6, and 7. So we do recommend that you take advantage of that audit right. And now I'm going to turn it over to Jennifer, this is a good segue, to talk about operating expenses.
Greetings. Operating expenses are a lot like and then have the taxes, but have their differences. The operating expenses, and Suzanne touched on this earlier, and I haven't. Oh, we didn't talk about the Tides Foundation.
Yes, this is another great nonprofit space in New York City, and I think some of the Tides folks are on the phone today. That's a space that includes nonprofit owners and tenants in downtown Manhattan.
So operating expenses, as Suzanne touched on earlier, are all the expenses, and this is again in the gross lease context, all the expenses that the landlord incurs in connection with operating, maintaining, repairing the building. The only thing that's really excluded other than real estate taxes, because they're reimbursed elsewhere, are costs of owning, acquiring, building the building. So you're not paying mortgage payments or construction costs, but other than that, you're reimbursing the landlord for every single expense they incur in connection with maintaining and operating the building. Your operating expense payment, much like a real estate payment, is a payment over a base year. And in this case, your base year is usually the calendar year. And as Suzanne mentioned, depending on the timing of the commencement of your lease, you may argue and negotiate to have the base year be the next year. So if you're signing a lease right now, having base year 2012 doesn't help you much. Sometimes the compromise is agreeing that the base year will be the next year, but that you won't have any payments for a full year. So that if your base year is 2012, you don't have any payments till November of 2013. It feels a little bit like a signing bonus, but when you first sign up for a lease, you don't pay anything over, often you don't pay anything over the base rent for some period. There's also rent abatements for the initial period too, but we didn't touch on that. So you, again, like real estate taxes, you'll pay your percentage of the building as a whole. Your percentage for operating expenses, if you're in a mixed-use building, may be a little bit higher than your real estate tax percentage, because if you're in a building that has retail on the ground level and office on subsequent levels, the retail tenants pay everything, including, they pay real estate taxes. They do not pay operating expenses because they don't get the same services that office tenants get, so therefore they're not included for purposes of calculating operating expenses. Again, like real estate taxes, you're going to pay estimated monthly payments with a true-up at the end of the year. One key thing to negotiate is exclusions from operating expenses, and both your lawyer and your broker will have a list that they love of these 33 things to try to get excluded, and you'll succeed to varying degrees. But the main things you want to get out of there are capital expenditures. The exceptions for, and I'm not advancing this, am I? The main thing you want to get out of there are capital expenditures. The exception to capital expenditures are expenditures that are, and you get this to varying degrees too, that are to reduce expenses of maintaining the building, like winter paned windows of some sort or something else causing inefficiency. If you're lucky, you can get them to agree that it's only to the extent it actually results in a savings, or to the extent that or if it actually has a savings. But usually what you'll get is to the extent that the landlord in good faith thinks it will result in a savings. The other is improvements that are required to comply with changes in law. But again, that should only be laws that came into effect after you took off, after your lease, so that you're not having to retrofit a non-compliant building on your nickel. Other capital improvements that happen during the term of the lease legitimately, such as replacing a roof or something of that nature, should be amortized over the useful life of the improvement, so that if a roof is going to last for 15 years, each year you're going to pay your percentage share of 1/15 of the cost of that roof. Like real estate taxes, you want to look at the survival period for your obligation to reimburse, and you want to cap that. Same way, like real estate taxes, and probably more importantly, you want the right to audit here. And if what will happen is you'll find in general that the landlord has a great survivability with regard to go back and charge you for things, and you, in contrast, are limited greatly on your ability to question the landlord's expenses. And so a typical audit right will involve you having the obligation within a certain number of days after you receive a statement to give notice that you want to audit, and then to audit. There will be certain criteria and limitations on who you can use to audit. They want it to be an accounting firm, although usually we can find a consultant, find an exception for consultants who are skilled at this. A lot of brokerage companies have someone who does this kind of work. They will in all cases prohibit that your auditor be paid on a contingent basis, and they will often have a confidentiality requirement, because if they're overcharging you, they're probably overcharging everyone, and they don't want that kind of landslide. But as Suzanne mentioned, you're going to want to audit as soon as possible, because each time you audit, you're often allowed to look back 3 years just for purposes of information, but you're only allowed to get a reimbursement, or rather usually a credit, for the amount you overpaid for the prior year. So you do not want to let that one lapse. Operating expenses are often grossed up, and this is perfectly fair and equitable in a situation where you have a base year. And what that means is that the landlord passes through the expenses for the lease, regardless of how occupied it is, as if it were almost fully occupied. So that, and this is a gross up only for operating expenses that fluctuate based on occupancy, such as janitorial expenses. So, for instance, if you in your first year lease a building that's half occupied, and the janitorial expenses are therefore half of what they would be if the building were fully occupied, they'll gross up that number as if the building, in our example here we're saying 95%, as if the building were 95% occupied, almost doubling that amount. That will go into your base year, so that next year if the building's fully occupied, you're not going to suddenly pay the entire increase because another tenant came in. It works out rather equitably so long as your base year is also grossed up. If it's not, you'll get a really bad result. If you're a larger tenant and you have the leverage, often you can negotiate a cap on annual increases in operating expenses, controllable ones, and those are things that are not of the ilk of insurance and weather-related cleanups and such. You'd like to limit the management fee that can be passed through to you, because often if you have an institutional landlord, a large landlord, they're going to have a management company that is affiliated or related to them, and so that's a profit center, and there's a market management fee, and you shouldn't be paying anything above that. So you just really want to look at these expenses. They'll be often the operating expense pass-through and the real estate taxes can be almost as much as your base rent, when combined, so you do not want to neglect these. Electricity. Electricity can be payable as a separate charge as additional rent. It can be included in your base rent, or payable directly by the tenant through submetering directly to the entity. If it's submetering, I think we all know how that works. If you're not contracting directly with the utility, but rather you're submetering and the landlord's acting as a middleman, you want to make sure they're passing along their actual cost and not charging you administrative fees, and that they're passing along any discounts they receive for volume use of electricity. If the landlord includes electricity and the rent, you want to make sure that you understand the amount that's being provided. First off, you want to make sure you understand from your architect and your consultants the amount that the building can provide to you and that it's sufficient for your use. And then you want to look at the lease and make sure that the amount that it allows you to use is sufficient for your lease, for your use. You also want to make sure that there's not something unusual about you that will make you different from the other tenants, because the landlord will, if that's the case, want the right to assess you for your additional use. And again, as Suzanne mentioned, you want to make sure that, especially in an older building, that the risers and the building structure itself electrically can support what you need. You can get this information from the landlord, or you can have a consultant help you with it, or some combination of both. Yes. Well, first off, you would. Okay. The question is, does electricity come up during the audit? It should come up in lease negotiation. You should both find out as a due diligence matter what the building can support, and then look. The lease will often, it will specify how much you're allowed to use. And the landlord, if he's charging you through for utilities, yes, that would come up through the audit. It depends on how you're paying for them, but yes. Okay, landlord's work and tenant's work. This is the work that's needed to be done to the space to get it so that you can use it. And there's a sliding scale of who's doing what. On the one spectrum, the landlord may be doing nothing, deliver it to you as is, or maybe gutting it and delivering it to you and you're doing all the work. On the other end of the spectrum, the landlord may be delivering it to you completely turnkey. So you want to be clear that you know exactly who's doing what, and that you have the requisite level of participation in what's going on. It may sound great on the one end to have the landlord do all the work because you don't have to worry about it, but then again, you may not get what you want. You need to make sure that you understand what the landlord's doing, that you understand what building standard means, and that you understand the ramifications of your input and what will constitute a change order or a tenant-initiated change. There's a lot of stress over the date of completion of the work, and if that date is missed, whose fault it was. The lease usually ties the commencement of the lease term to the date the landlord finishes their work. And then the rent commencement date is usually some date later, which builds in enough time for the tenant to do their own build-out work so that you have a free rent period there while you're doing that work. If the landlord fails to deliver possession timely, it often results in a pushing out of the commencement date and a corresponding push out of the end of the term because the landlord's bargaining for, say, that 10-year term. But at some point, you need some remedies when you haven't gotten the space in time, because you're in space probably already. You're probably in a holdover situation, which means you're paying 150% or 200% of your normal rent. And now, through no fault of your own, you can't get into the new space. Landlords will often want you to take the hit for the first portion of that delay, and then at some point, they'll start giving you a credit for that additional rent and delay that you're suffering. The problem is usually that the landlord wants to reimburse you day for day for the amount of time, for the amount of additional expense you're experiencing because of their delay. So if they deliver the space 15 days late, they want to give you 15 days of expenses. The problem is your old lease will provide, and strangely enough, your new lease will provide, that if you hold over, you don't hold over day for day, you hold over on a month-to-month basis. So that if the landlord's 15 days late, you have 30 days at 150% rent. So these are things to think about and negotiate, and then to decide at which point you need to move on, which is hard because then you have to start over. And the landlord will fight tooth and nail to have you have a kick-out, against you having a kick-out right. Their lender doesn't like it. Their construction lender doesn't like it. So it all depends on leverage. And you also want to find out that you want to be sure that you understand that the existing tenant's already out of the space, because that's one thing that could really delay the landlord's ability to timely perform.
Jennifer, I would just mention that sometimes looks are deceiving. You'll see a space that looks vacant. You'll see a space that might even not be fully built out, and it's wrong to assume that that space is not subject to a tenancy. And in fact, about 5 years ago, I negotiated a lease for a client, and it had concrete floors. It it had no walls. It was really not built space at all. And we added representation in the lease. So we asked the landlord to represent that there were no current tenancies. And we got to the very end of the lease negotiation, and they said, they had us sign the lease, and we sent it to them, and they said, we're going to need about 2 weeks because we need to work out a surrender with the existing tenant that we heard about for the first time. So it's good to not take that for granted.
Yeah, good point. Okay, as to the tenant's work, in general, every single improvement you make will require the landlord's consent, whether at the beginning of the term or during the term, with the exception being cosmetic improvements and improvements below a certain threshold cost-wise. So that's things like painting and carpeting. You want to make sure the landlord has a reasonability standard with regard to your improvements. And you want to, for your initial improvements, if you know what they are, go ahead and have the landlord pre-approve those so that you're not getting into a deal where you're not going to be able to put in the improvements you need from the get-go. And that's also when the majority of the improvements you're going to make are going to happen, so you can get that out in the beginning. In terms of the process, you want to build in timelines if you're doing work for the landlord to respond, and then for the landlord to, if they don't respond, if you can get this, to have deemed approval, say after the second notice and the lapse of the second 5 or 10-day period. As far as who your contractor is, if you're still in the stage where you're picking a contractor, yet you have 3 or 4 in mind, it's prudent to go ahead and get the landlord to pre-approve those contractors so you don't end up in a situation where the landlord's forcing you to use its preferred contractor even though that's someone you would never otherwise use. Same thing with insurance requirements. Then in terms of the tenant improvements, there's often a tenant improvement allowance which the landlord's going to mete out to you if you're doing the work. If the landlord's doing the work, doing the majority of the work at the beginning of the term of the lease, the landlord is going to agree to deliver to you certain specs, and they'll do whatever it costs, but the point is they're controlling the process, and there the key is to make sure that the specifications are what you want them to be. If the landlord's meeting the work out to you, meeting the funds out to you, you want to find out, first of all, you need to worry, especially given the larger the tenant improvement allowance, the more you need to worry about the landlord's ability to actually pay the sum. So if you have $65 a square foot, if you have a big enough space, that turns into $2 million really quickly. And then you worry about the landlord being able to reimburse you. So one way to protect yourself is to make sure that your reimbursements are monthly and not at the end of the time when the work is done. If you have much larger allowances, you can get to the point where you have the landlord's lender recognize your right to reimbursement. You can get that in an SNDA. You can require the funds be escrowed. You can talk to the landlord's lender, but that's when there's a legitimate concern given the size of the tenant improvement allowance that you're worried about it being paid, especially if you have any wind that the building might be being sold anytime soon. You just want to make sure that everybody knows, and you'll do that through an estoppel process, that this money is owed to you. You want to be clear about what's reimbursable. Landlords are loath to allow this TI allowance to be used for anything other than things that actually inure to the benefit of the building if you were to go away. They want it to be sunk into the building in improvements and fixtures. So things like your furniture and your moving expenses, while they're a legitimate part of your getting into the space, they're not automatically included in the tenant improvement allowance. But you can negotiate that in a lease up to a certain percentage, say 15 or 10, 15, 20% of the allowance can be used for things of that ilk, computers, computer installation, moving, furniture. Also, if you think you're paying for this tenant improvement allowance, it seems like money they're giving to you, but they're giving it to you, they're amortizing it into the cost of the rent over the term of the lease with interest, with high interest. So make sure you're using it. And so if you think there's any chance that you might not use it, first you want to see if you can use it for these kind of expenses. And then second, up to a threshold, you want to see if you can use it as a credit against rent for the first period. You want to watch out for landlord supervision fees. If they're going to charge them, you want to know what they are and limit them as much as you possibly can to protect your cost of construction so that your tenant improvement allowance doesn't go back to the landlord. Okay, in terms of assigning and subletting, and these are strategies for maintaining or dealing with the cost of the lease over the term when it's not really what you expected. You may need, well, first, I'm sorry, let me explain the difference. Assignment, in an assignment, you transfer all your rights to a third party, and you, in all likelihood, still remain on the hook to the landlord. If you're express about it, and it can be negotiated that you are off the hook, but often you remain on in the role of a guarantor of that assignee's obligations. Alternatively, you can sublease, and a sublease is either, it keeps you in privity with the landlord, and so you are primarily liable, and then you collect from the subtenant and pass the expense on. But you can also do only a portion of the space that way. I think if you're at all worried about if you're seriously worried about the creditworthiness of your assignee and you're not getting off the hook in the assignment, which if there's some worry about the creditworthiness, the landlord's not going to let you off the hook, it would behoove you, even though it keeps you involved for a longer period, to be a sublandlord. And therefore, if the subtenant fails to perform and files bankruptcy like someone did last week, at least you, once you get through the bankruptcy process, can take the space back and either use it or sublease it to somebody else, as opposed to an assignment where you've relinquished all your rights in the lease. As a general rule, assignment and subletting, my flipping these sheets is in no way tied to advancing the slides. It's disturbing. As a general rule, assignment and subletting is not permitted without the consent of the landlord. You want to get a reasonability standard on that. There are things that the landlord is going to absolutely have as criteria where they say, I can refuse to consent for these reasons and I'm not being unreasonable. One is, the real hot button is that tenant is otherwise somewhere in the building or otherwise looking at the building. And they do not want you competing with them. They do not want you undercutting them on rent so that they're now competing with you to get rid of other space they have in the building. So you're going to want to negotiate certain exceptions where they don't look into that, and so, or where you may not need consent, and those would be assignments to affiliates. In the case of a nonprofit, affiliate or sponsor organizations who may want to use the space with you or to whom you'd want to assign the lease. Or if there were a sale or transfer of all the assets of your entity, especially if you're not trying to get out of the lease, if you're trying to continue going on as a going concern, you want the right to preserve and keep your lease and transfer it to that successor. The process for assignment, usually you have to give the landlord notice way in advance and give them about 30 days to mull it over. So you'll want to build that into your timeline. You may want to pre-vet things with a landlord and take their temperature and find out before you even know who your prospective subtenant or assignee is going to be, what the landlord thinks about that and how they're going to react. Often landlords insist that if you have a right to assign or sublet to an unaffiliated third party, you can usually get an exception if it's an affiliate. But if you're going to assign or sublet to an unaffiliated third party, they want the right to recapture and take the space back. That's not necessarily a bad thing, because if you're trying to assign or sublet to an unaffiliated third party, you're probably trying to get out of the space. You may want to look at, in that instance, who bears the cost of demising and whatnot. If the landlord's going to take back only part of your space, that's not free. But it does decrease your flexibility. It does mean that you want to shorten the amount of time the landlord has to react to your request as much as possible, because just like when the landlord's dealing with your expansion right or right of first refusal, you have to worry about finding somebody who's ready, willing, and able to sublet your space, and then finding out that the landlord's going to take that away from you. If you make any money in the subletting, that profit will have to be split with the landlord, usually 50-50. You want to be really clear about what profit means, so that that's net of the broker's fee and the cost of refitting the space and the lawyer's fees, et cetera, so that you're really only sharing the true profit with them. And assigning and subletting leads right into ways to get out of a lease. The first and most obvious would be a landlord default. You find a lot of leases don't have a landlord default section. It's usually, I think, the most difficult, absent really egregious behavior on the part of the landlord. You have rights at law, but they don't spoon feed you the kind of notice and cure period and laundry list of defaults that a tenant would normally have. You certainly negotiate it in, but it doesn't. The leases magically do not appear that way when they're first given to you. That's going to be your hardest one. If it's really egregious and obvious, you're going to have rights. You're going to be able to get out for landlord default. As Suzanne discussed earlier, there's the negotiated early termination. Negotiating it up front is something you're only going to be able to do if you have a strong business argument for it and you're of sufficient ilk and importance to the landlord that they'll agree to this. Negotiating it later when things are not going so well, it's still doable. It often involves you having to come up with a sufficient amount of money to make it worth the landlord's time to terminate your lease early using the money you've given them to cushion them during the period that they use to relet the space. And it also helps if the landlord is in a situation where they're feeling that at least they get 6 months, 1 year, 2 years rent out of you now, and they may be able to relet it before that's burned through versus watching you slowly default and become insolvent.
Jennifer, there's a question from one of our web participants that ties into this. If a tenant wants a 5-year lease ideally, but the landlord's pushing for a 10-year lease, I'd be interested in hearing whether there are any creative solutions to agreeing to the longer lease but with some right to earlier cancellation.
Okay. Well, yes, and you can agree to, the landlord, definitely if you have an early termination right, they want to know when you're exercising it. They're not going to let you exercise it at any point. I think Suzanne mentioned this. But it would be the equivalent of having a 10-year lease with a 5-year, with the option to terminate effective as at the end of the 5th lease year, upon payment of some fee that would cushion the landlord for the downtime to get it relet, plus, and I've seen this, repaying the unamortized expenses of the landlord in getting your 10-year lease in, because he paid a broker based on a 10-year term, which is, I just lost the, thank you. He paid a broker based on a 10-year term, and now he's getting 5 years of rent out of you, so you're going to have to pay the remaining 5 years and unamortized legal expenses. The tenant improvement allowance that you received, again, was only amortized over a 10-year term, so they've not been paid back. That said, that flexibility may be worth it to you, and you don't have to exercise it. Thank you. The other option, thank you. The other option we discussed is assignment and subletting. And again, as I already said, it may be subject to a right of recapture. The entire transaction, including the documentation, is going to have to be approved by your landlord. Your assignee is going to have to step into your shoes and assume all of your obligations for the remainder of the term. The other option being subletting. Thank you. The subtenant is only going to have rights that are derivative from your rights. They're not going to have any more rights than you do. They're going to be subject to your lease. You're going to have to play middleman and collect the rent from them and pay it to the landlord. You're going to have to enforce the landlord's obligations for their benefit and be in the loop the entire time. As with any other subletting or assignment, you're going to build in ample time, make sure that you've thought about the times where the landlord has to react, to approve, to exercise a right to recapture. And know that if your landlord digs in and is just unreasonable and will not approve your assignment or your subletting, he will, in all likelihood, not be, for the terms of the lease, liable for damages, but rather you'll have the pleasure of having to sue and get a court to decide that they're being unreasonable. One other thing we build in up front for a lot of nonprofits is license and desk sharing arrangements. You have these affinity groups that want to use a space with you, and they don't need it separately demised. They want to take 3 of your 12 offices and use your conference room not more than twice a week, more than twice a week. And you have some sort of related business goal that makes that work and makes that make sense, and people do that a lot. And so long as you negotiate it up front, even if you don't, if you're using a small enough percentage, if you can make a business case for why it makes sense, and most nonprofits can, if you're agreeing that it will never be more than a certain percentage of the total space in your leased area, they don't want you to run a business where you're just doing this with third parties. If you agree that it will be undemised and there will be some affiliation, landlords will often agree to this. So that's something you want to negotiate up front and think about as an option if you need to downsize, or if you need for it just as a business matter to co-locate with somebody who has a similar business model. Also, nonprofits often seek to co-locate with other nonprofits in order to save these costs and for mission-driven reasons. in some instances, they purchase a building for this purpose, but if that's not practical, they may be able to achieve the benefits of co-locating by leasing a separate premises in the same building. If you do this, though, each of you should have a separate lease or a separate license agreement, contractually separate, because while things are good, it's fine, but when they're not, you're going to need to make sure that you are protected. There are other reasons, which we didn't get into today, why a nonprofit may want to own the building, period. There's great tax benefits. There's also financing opportunities that aren't available when you're leasing. So, a facility within the building, such as like a gym or a kitchen, may be used by one nonprofit. It may be shared by others, but you're going to need to have that papered, have the rights and arrangements documented. You're going to want to think about insurance issues, especially things like kitchens where multiple people are using it, and make sure you cover that out. Now I have another building. Cooper Union? Great.
Just a great nonprofit building.
That's very illuminating, Susan.
It's pretty.
Brand new building, not the building where Abraham Lincoln gave his address before becoming president. That's the newest Cooper Union building.
And this is Jeff. Let me interrupt for a second. We may be having, I can't tell from this end, some technical difficulties for those of you on the webinar. The slides may not be advancing the way they are here in the room. So I apologize for that. You should have access to the PowerPoint slides, irrespective from the confirmation email that was sent out, and we're currently on slide number 45.
The question? Okay, well, if it's a lease that, oh, I'm sorry, the question is, what is the landlord telling you when they choose a lease versus a sublease versus a license? The lease indicates that, it should indicate that the landlord is the owner. There could be a ground lease below it, but in general it means that your landlord owns the building. If it's a sublease, in general it means that your landlord is a tenant of the building. And so then the first question you want to ask is, where is the prime lease or the underlying lease, because all of your rights are derivative. You need to see that, and you should be on notice that you need the prime landlord's consent for your sublease.
Yeah, there have been many instances where clients will send us over a proposed lease to take a look at. I'll send it over to Jennifer, and then she'll have to follow up with the client to ask them for their lease, because they're not the owner, their lease with the landlord, and that's absolutely critical and has a big effect on what Jennifer can negotiate.
Right, and it affects the timing, because you know that you'll negotiate your entire deal, and then it's subject to prime landlord consent. But usually build in a contingency that if the prime landlord just doesn't consent within 30 days, that it's revocable. This often is a problem, though. People usually don't have that much time built in. And then a license it can often feel just like a lease. It's often a sublease situation. As far as your actual ability to exercise your rights, you're considered to have fewer rights than in a sublease, although practically speaking, if you have a license to which is in accordance with the lease, which is not breaching the lease that underlies it, you should be fine. I would be wary of people who say, oh, we don't need the landlord's consent because it's just a license. This isn't a sublease. You might run into problems there. So people shouldn't think that that's okay. But it's meant to convey that there are fewer rights granted.
I think a license is also usually associated with something that's easily revocable, short-term, and much more limited in scope. In fact, legally, a license is not an interest in real property. But the effect of it is that it's used in short-term situations, and it gives the occupant a lot fewer rights.
I would just be wary of thinking that it wasn't something that rose to the level of needing the landlord's consent. I find people think that that's, oh, we'll just call it a license. That won't work. Okay, on to utilities and building services. It's important to note that the landlord is only obligated to give you those services that are expressly spelled out in the lease. You should not assume you're getting anything that's not in the lease. You should pore over those services and take them very seriously. Electricity will be, we talked about that earlier. HVAC, heating, ventilation, and air conditioning. The landlord's going to provide this usually only during certain hours, whatever the landlord considers the building standard hours. You're going to make sure you know what those are, that they're spelled out in the lease, that they work for you and your business model, and that they're weekend hours if you need those. Typically a building will have 12 hours a day during the week, but maybe 4 hours on Saturdays. You want to make sure that you understand what it takes to get the service on Saturday and Sunday if you need it, what the notice requirements are, what the landlord's going to charge for that. You often like to say it'll be the landlord's actual cost, but it's often surprising that it's not just the cost of utilities. There's an engineer who has to be involved and all sorts of other things. So the cost of having weekend service is often rather prohibitive, so you'll want to coordinate on that. If you're providing the HVAC yourself for your space, which often if you have a special use or high computer output you'll be doing, you want to make sure that you understand what your obligations are with that. The landlord may install it and then you have to maintain it. You want to make sure you understand that, understand if you need additional condensers or things of that nature to run that system. Jumped ahead there. Separately, water and sewer is often included in standard lease terms. You would think it would go without saying, but you need to find out whether hot water is included at the building. That may or may not be included. I think generally in a Class A office building in DC, that's included. That's not going to be an issue. What's never included is telephone and internet. You're always going to have to take care of all your IT access needs yourself. You're going to have to make sure that the building risers and spaces are sufficient for your needs. You'll also want to understand, although you may be able to negotiate around it, but usually not, that you're going to have to remove all that cabling and wiring at the end of the term to get it out of the landlord's way. Cleaning. Janitorial services are included in the cost of the rent. You want to find out the frequency, the scope. It's usually attached as an exhibit to the lease. You want to make sure that it's sufficient for your needs. You want to find out whether garbage removal is included. Security. You want to find out if it's provided 24/7, and if it's not, how are you going to get into the space? You want to talk about access cards, the number of cards you're getting, who's paying for them, and how are those arrangements made. And then as to all these services, to the extent they're not provided, okay, thanks. To the extent it's not provided, you want remedies for the failure to provide these services. In general, a landlord is going to provide you the right to abate rent only if the services are not provided or access to the building is not available for a certain continuous period of time, say 3, 5, 7 consecutive business days, after which point you become entitled to an abatement. You have to request this, negotiate this. It will not automatically be in the lease. There's often a notice requirement before the abatement kicks in. So the landlord doesn't want to hear on day 5 that you're going to stop paying your rent because you didn't have certain utilities. We were discussing before this program what's probably happening in New York with regard to various leases and whether anyone sought to send those notices out to their various landlords with regard to those abatement periods. Also negotiable is if the failure of access, and again, you have to actually, sorry, I don't know if I clarified this, you have to actually be unable to and not use the space in most cases for you to be entitled to any relief for failure to have the services. If it continues for a sufficient period, say 30 consecutive business days, which is longer than it sounds, you often can negotiate the right to terminate your lease. You do want to talk to your insurance provider and see what kind of business interruption and other insurance coverages you can obtain to help you further protect yourself against this loss, because a mere abatement of rent is not going to make you happy when you're not using your space for long periods of time. How am I doing this? Okay. Okay, sorry. Well, now we're at Jazz at Lincoln Center.
Okay, while Jeff is working on the slides, Jazz at Lincoln Center is a project that Venable Attorneys worked on the design and construction of. It is the first facility in the United States that was designed specifically for the performance of jazz music of this scale. It's a design, performance, and education facility, part of Time Warner Center. Venable attorneys also worked on the design and construction of the Cooper Union building, which you saw before.
I'm going to turn this back over to Suzanne now for leasing and green buildings.
I want to leave time for some questions, so I'm going to go through this real quickly. But for nonprofits, my experience has been that they have been at the vanguard of the green building movement. It's largely mission-driven, and in the context of leasing, a tenant can seek out a green building or can commit to it within its own organization to build out its space in an environmentally sustainable way. Probably most of you are familiar with rating requirements such as LEED, which are sets of criteria that one has to meet to achieve a certain rating, which is given by the U.S. Green Building Council. A shift that we're seeing in green building law is that a lot of people are moving away, and governments are moving away from ratings that take place at the time that a building is put into service or that an interior is completed, and they're going to rating systems that are looking at the effect of those green improvements. And this is great news for tenants because as this information is compiled, you can get a sense of the relative efficiency of a building that you're thinking of leasing in or that you are currently leasing in. One example of this is in New York City, fairly recently enacted Local Law 84, which requires most private owners of large buildings in the city to provide information, all sorts of information about their energy and water consumption. And the city compiles this information, puts it in a report, analyzes the information, and it makes available to you both the raw data and just an overall analysis of building efficiencies. You can look at that data if you're interested in leasing in one of the buildings that's on that list. You can find out what its Energy Star rating is and a whole host of other information, and your architect can access that information, and it's a really great tool. And that's called benchmarking. The city wants to compare, and users also want to compare. Just some final thoughts about green buildings, two sides of the same coin. You may be interested in concept in leasing in a green building, which might be green because the landlord has achieved a LEED rating, or it might be green because there are some type of requirements by a lender or a municipality that the building be green. But one thing that you need to understand before you enter into that lease is that going to require you to pursue repairs, capital improvements in a sustainable way? And maybe it does, and you think that's great, and you're committed to it, or you might think that that's an additional cost that you don't want to incur. So that's something that you should explore. The flip side of that coin is Jennifer talked a little bit about limiting the tenant's participation in capital improvements. Another way to think about sustainability is to partner with a landlord and agree to pay for certain types of sustainable improvements, capital or otherwise, that you'd like to see in the building. And that's a way of advancing sustainability in a building that you don't own. That really takes us to the end of our presentation. So, Jeff, do you want to organize Q&A?
Yeah, anyone here in the room have any questions? And while you guys are gathering your thoughts, Jennifer, if you have any final thoughts for Suzanne and anything that we didn't get a chance to touch on, feel free to offer that up. Any questions for Suzanne or Jennifer? Yeah, back in the corner.
I don't know that I've actually seen, I'm sorry, So the question, correct. So the question is, with regard to audit rights and the confidentiality requirement that the landlord might want to impose on the auditor, is it reasonable for the landlord to proffer up the form of confidentiality agreement at the time the lease is signed? I don't think it's unreasonable. I've not seen it done. The thing to do would be to make sure you read that confidentiality agreement and, in fact, review it with a consultant. If you have one in mind who you anticipate might be doing the audit, to have them go ahead and look at that and give you some feedback to get ahead of it. It is very typical for a landlord to impose a confidentiality requirement. They do not want an avalanche of objections to their audit charges. So I've not seen it in advance, but it doesn't seem unreasonable if you can make sure the form is reasonable.
Yeah, right here.
Okay, so the question was, if you're on a mixed use or mixed tenant floor and you don't have a service, and in this case it's internet and a shared conference room, are there any strategies for talking the landlord into putting that service in? So it's a shared conference room that you're all coordinating the use of? Certainly you can make a condition to renewing, obviously. If you have other options for renewal, but now again your leverage is decreased if you think that this is a really great bargain and you really don't want to move. But certainly if you can find out the renewal times of the other tenants and maybe agree that this is going to be something you all keep mentioning to the landlord, maybe they will realize it's inevitable. And the cost is just, the landlord has said the cost of installation is prohibitive, or is it the cost of providing the service, or both?
I'm not sure.
Okay. You can certainly collaborate with the other tenants. That's your best course of action.
You might also be able to, if it's just the installation cost, because I would think you would pay for your usage, you might be able to work out some deal where the other tenants and you all agree to pay a portion of the cost, and maybe if financially that's difficult for the tenant group, maybe that can be amortized over time with some type of interest so that the landlord could actually get back all or some portion of that installation cost over time with interest. Could be added to your rent payment.
And then the other upside for the landlord is to point out that now this amenity will be built into the building, and maybe you'll only pay some together. You'll only pay some percentage of it, but now they've got this improvement that they can use to market the building going forward. That's a good idea.
Yep, right here.
Building on that question, given that we're talking on average 10-year leases and technology is evolving fairly quickly, are there any standard clauses that you guys recommend be included to ensure that the lease space evolves in terms of its capacity to handle that evolving technology?
I have seen sorry, the question is whether in view of rapidly changing technology, whether there are measures that tenants can take to ensure that they have sufficient space in the building and access to new technologies in the future. I think landlords generally are not providing these types of services. Your case sounds more like a turnkey type of office, but maybe in a larger office building or a larger user is going to expect to bring things like internet to its space itself and other technologies. But I think one thing is key is to have room in the risers, because all of these things are, there's a requirement that there be space in the building to run these things from ground level. And one thing that I have seen recently is that tenants will look with their architect at spaces and investigate, probe, and see what space is available in risers. And if there's something that's anticipated, to try to get a commitment from the landlord to make space available in some other riser, even if they're not currently using it and it's not currently within their premises, if they should need it in the future for some reason. That's typically in connection with something that's anticipated, though. Do you have any other ideas on that?
No, the thought is just remembering that your scenario is different. Usually you're providing the technology to yourself, so as Suzanne said, it's just necessary to make sure that you have the ability to use portions of the building to get it to yourself. But having a 6-inch conduit or a certain space and riser that you can use does give you flexibility because you're going to be installing whatever you need in there, so typically.
And final question, Ezra?
Right, right. And most leases do provide the landlord with the right to make de minimis types of penetrations for the benefit of other tenants. So you as a tenant can be the beneficiary of that if the landlord needs to allow you access to put in some type of equipment that you want to that's going to run vertically.
Okay, I want to thank everyone for joining us today. Especially I want to thank our speakers, Suzanne and Jennifer, for a terrific job. Reminder, we have a program this coming Friday, the Postal Service Financial Crisis, What It Means for Nonprofit Mailers, and our program next month, a very important and interesting hot topic that many of you are dealing with, exchanges under healthcare reform and private exchanges, what does my nonprofit need to know? That's on December 11th. Hope you guys can join us for that. Thanks again as always, and we'll see you next month.
Thank you. Please stand by.